It is extremely important for us to note at this stage that the provisions of exception 2 have been laid down or modified by the Supreme Court in 2017 in the case of Independent Thought versus Union of India. The issue before the Supreme Court in this case was whether sexual intercourse between a man and his wife being a girl between 15 to 18 years of age is rape. The court said that as per exception 2 to section 375 IPC, such a sexual intercourse is not a rape, but in the opinion of the court, sexual intercourse with a girl below 18 years of age is rape regardless of whether she is married or not. The court said that the exception carved out in the IPC creates an unnecessary and artificial distinction between a married girl child and an unmarried girl child and has no rational nexus with any unclear objective sought to be achieved. Which means this classification is in violation of Article 14 of the Constitution, which though permits reasonable classification, but there has to be a rational nexus with the classification and the objective which is sought to be achieved by that particular provision. Further, exception 2 is discriminatory in that this is the only provision in various penal laws which gives immunity to the husband. Any sexual act with a girl under 18 years of age is punishable under section 376, but by exception 2 an immunity has been given to the husband. The court observed that if the husband beats a girl child and has forcible sexual intercourse with her, he may be charged for offences under section 323, 325 IPC etc. But because of exception 2 to section 375, he cannot be charged with rape. This leads to an anomalous and astounding situation where the husband can be charged with lesser offences like hurt or grievous hurt, but not with the more serious offence of rape. Further, as far as sexual crimes against women are concerned, these are covered by sections 354, 354A, 354B, 354C and 354D, and there is no exception clause giving immunity to the husband in any of these sections. Further, exception 2 is in conflict with POCSO. Let us see what is the conflict. Whereas the husband does not commit rape under section 375 IPC when he has sexual intercourse with a girl child between 15 to 18 years of age because of exception 2, but he commits aggravated penetrative sexual assault under section 5N of the POCSO Act. So this is an offence under the POCSO Act, and the offence is of that of aggravated penetrative sexual assault. There is no real or material difference between the definition of rape under section 375 IPC and penetrative sexual assault under section 3 of the POCSO Act. There is a provision in the POCSO Act itself which gives overriding powers to the provisions of the POCSO Act. This is section 42A. This section provides that in case of any inconsistency between the POCSO and any other law, it is the POCSO which will have an overriding effect to the extent of inconsistency. Moreover, POCSO is a special act dealing with children, whereas IPC is a general criminal law. Therefore, in case of inconsistency or conflict, it is the POCSO which will prevail over the IPC. Exception 2 to section 375 IPC, insofar as it relates to children, is inconsistent with POCSO, and to that extent, POCSO would override this exception. The court concluded that to harmonize the system of laws relating to children, exception 2 to section 375 requires to be meaningfully read as sexual intercourse or sexual acts by a man with his own wife, the wife not being under 18 years of age, is not rape. Now the effect of this judgment is that now if a man commits any of the sexual acts which are specified in the first part of section 375 with his wife, it will amount to rape if the age of the wife is under 18 years of age. Whether consent is there, whether consent is not there, consent is not material. If the age of the wife is 18 or above, then any of these sexual acts committed by a man with his wife will not amount to rape even if there is no consent of the wife. Proceeding next to the trial in a rape case, a question very often asked is this: is corroboration required for testimony of a rape victim? When a rape victim appears in court and deposes before the court, records her evidence before the court, can a court convict on the basis of the sole testimony of the rape victim without there being any supporting evidence? This is the question. And the answer was given by the Supreme Court in 1996 in State of Punjab versus Gurmeet Singh in the following words: testimony of the victim in rape cases is vital. Evidence of the rape victim is vital. And unless there are compelling reasons which necessitate looking for corroboration of her statement, courts should find no difficulty to act on the testimony of a victim of sexual assault alone to convict an accused, where her testimony inspires confidence and is found to be reliable. This is a statement of law which says that where the evidence of a rape victim inspires confidence and is found to be reliable, the courts can record conviction on the sole testimony of this rape victim unless there are compelling reasons which necessitate looking for supporting evidence. To sum up, the sole testimony of a rape victim is sufficient to convict the accused. Courts cannot cling to a fossil formula and insist upon corroboration even if, taken as a whole, the case spoken of by the victim of sex crime strikes the judicial mind as probable. The Supreme Court added in this case that it would be adding insult to injury to tell a woman that her claim of rape will not be believed unless it is corroborated in material particulars, as in the case of an accomplice to a crime. We know that the evidence of an accomplice needs to be corroborated. That is the rule of caution which is laid down in the Evidence Act in section 114 clause B, and the Supreme Court says that it would be adding insult to the injury if a rape victim is equated to an accomplice. She is not an accomplice, she is a victim, and therefore there cannot be insistence on corroboration of her evidence. In State of Maharashtra versus Chandraprakash Kevalchand Jain in 1990, the Supreme Court observed that if the totality of the circumstances appearing on the record of the case discloses that the prosecutrix, that is the rape victim, does not have a strong motive to falsely involve the person charged, that is the accused, the court should ordinarily have no hesitation in accepting her evidence. The court can record conviction on the basis of the sole testimony of a rape victim unless there is a strong motive with her to falsely involve the accused. In State of Punjab versus Gurmeet Singh, the court said that while appreciating the evidence of a prosecutrix, that is a rape victim, the court may look for some assurance of her statement to satisfy its judicial conscience, since she is a witness who is interested in the outcome of the charge leveled by her. Now, it's no doubt that the charge has been leveled by the victim, and it is also not in doubt that she is interested in the outcome of the case. So, the court may look for some assurance of her statement to satisfy its judicial conscience. But the court emphasized that there is no requirement of law to insist upon corroboration of her statement to base conviction of an accused. There is no requirement of law. It is only for the court to assure itself that it may look for some further evidence. One more question is there. Is the past conduct of the rape victim relevant? This question was also answered in the same case, State of Punjab versus Gurmeet Singh. The court said that even if the prosecutrix, that is the rape victim, in a given case has been promiscuous in her sexual behavior earlier, she has a right to refuse to submit herself to sexual intercourse to anyone and everyone, because she is not a vulnerable object or prey for being sexually assaulted by anyone and everyone. So her past record is immaterial as far as the conviction in a given case is concerned.